Hello and welcome to the Employment Tribunal Rules series of talks. In this talk I'm going to be dealing with the part of the rules that deals with the rules which are common to all kinds of hearings. My name's Declan O'Dempsey, I'm a barrister at Cloisters Chambers. The first and general point to note about tribunals at a hearing is set out in Rule 41 of the new rules. The tribunal is basically entitled to regulate its own procedure. However, it must conduct the hearing in the manner that it considers fair, having regard to the principles contained in the overriding objective. So remember this if you're criticising the tribunal's conduct. It has a broad scope for its discretion, but there is this limitation that it must have regard to the principles contained in the overriding objective. Rule 41 also makes the point that the detailed rules of procedure that we're about to have a look at don't restrict the general power to regulate its own procedure. So it's entitled to avoid undue formality. It may itself question the parties or any witnesses so far as appropriate in order to clarify the issues or elicit the evidence. Now it's always worth mentioning to your witnesses that they may get questions from the panel at any point in giving their evidence, but the same applies to any representative as well, because the tribunal is entitled to pin you down on the issues and to get the evidence out in the best way that it can. It won't necessarily turn into an inquisitorial tribunal, so it won't take over the running of the case, but it is entitled, according to this rule, to question the parties or witnesses to elicit the evidence. And this reflects very much the practice of the tribunals up to now in any case. It's not bound by any rule of law relating to the admissibility of evidence in proceedings before the courts. So forget everything you've heard about hearsay being inadmissible in court proceedings. It's not only permissible, but it's very commonly used in proceedings before the tribunals. The really important point to bear in mind about hearsay evidence is its reliability rather than the fact that it's hearsay, because you may have some very reliable chains of hearsay because you know at each point that the link in the chain is reliable. On the other hand, there may be certain chains of hearsay evidence where one person who relays the information onwards is plainly unreliable or has plainly misremembered what they've been told. Generally speaking, however, tribunals will accept hearsay evidence for evaluation and then give it what weight they see fit. So that's the process of evaluation of hearsay. It's a question of the weight that the tribunal chooses to attach to it. I want to say a little bit about Rule 42 and written representations. There's an obligation on the tribunal to consider any written representations in certain circumstances from a party. If you deliver your written representations to the tribunal and all the other parties not less than 7 days before the hearing, then the tribunal must consider the written representation. However, even if you don't satisfy that rule, the tribunal may consider them. In either case, if the tribunal decides or is compelled to allow the written representations to come in, then the weight that they will give to them, if they purport to be evidence, will be up to the tribunal. So you can use this to bring in a witness statement from somebody who's not going to attend the hearing. But of course, that witness statement will not have been subjected to cross-examination, and therefore, naturally, a tribunal will be likely to give it less weight than the evidence of somebody who has attended the hearing and whose evidence has been tested in cross-examination. The evidential value of it, therefore, may well be diminished unless you can show that there's good and known reason for the non-attendance of the witness. Rule 43 sets out provisions relating to witnesses. The written witness statement is now going to stand as the primary evidence of the witness called to give evidence, unless the tribunal orders otherwise. So, unless the tribunal orders otherwise, your witness won't read out the witness statement in order to give the primary evidence, the evidence in chief. The witness instead will go almost immediately into being cross-examined, and that means that your witness statement has to be well constructed, readable and clear, and properly cross-referenced to the bundle. Witnesses still have to give their oral evidence on oath or affirmation. In practical terms, this means the clerk will come up to you in the waiting room and ask who is here to give evidence. The claimant does count as a witness, so include them. The clerk then takes details of how you want to take this step of promising to tell the truth, either by giving an oath or making a civil affirmation. The tribunal can exclude from the hearing anyone who's going to be giving evidence in the proceedings until they've done so. But it can only do that if it considers that it's in the interest of justice to do so. And traditionally, tribunals have only exceptionally taken this course. If you want a witness excluded in this way, ask the tribunal, give the basis on which you think that the witness should be excluded, because in most cases it's not necessary. It might be worthwhile making the application if you've got real evidence of potential collusion, in which case you should bring that to the attention of the tribunal when you're making the request. The climate of open justice requires that, because witness statements stand as the primary evidence, members of the public should be entitled to inspect the witness statement, even as they'd be able to sit and listen to somebody giving their primary evidence orally from the witness box. Well, the way the tribunals deal with this is by Rule 44. The witness statements have to be available for inspection during the course of the hearing by members of the public who have attended the hearing. Clearly, the tribunal can decide that all or any part of the statement isn't to be admitted as evidence, in which case that statement isn't to be available. There are exceptions to this where the privacy rule, Rule 50, is applied, and we'll look at that in a minute, and also national security proceedings under Rule 94. I don't propose to say very much about those at this stage. Note that the person who's seeking to inspect has to attend the hearing, so it can't be done remotely. The idea is to model what would be available to a member of the public if they had actually attended the hearing. A very important aspect of the new regime is keeping an eye on the use of tribunal resources. One manifestation of this is Rule 45, which reflects a practice that has been present in the tribunal for some time, but I think will be used more frequently under these new rules. So a tribunal can impose limits on the time that a party can take in presenting evidence or questioning witnesses or making submissions, and may prevent the party from proceeding beyond their allocated time. So this is a really difficult thing to work out if you're trying to represent yourself. By the time you've finished your preparation for the case, however, you will have a fair idea of how many themes you need to question a witness on. Try and imagine how long it's going to take you to get through those themes, and just as importantly, try to make sure that you keep to relevant matters. Think how long, with your knowledge, if you have any knowledge of the witnesses may take to answer, and that'll give you some idea which you can then put forward if you're asked to say how long you think you're going to be with witnesses. It may be worthwhile sitting down with a table of witnesses and working out how long you think you're going to take with each of them at quite an early stage, because that'll enable you to get the right time allocation for the hearing. I'd suggest that when you're considering submissions and you're not used to doing them, I would sit down and practice doing them and time yourself. If necessary, record yourself. That can be a useful way of seeing whether or not you're taking far too long over a point, or how you look when you're making these submissions. Now, obviously you're not going to be able to know the submissions you're actually going to make when you're practicing them, because you may have to deal with all sorts of things that come up from the other side or from the witness evidence. But nevertheless, try to explain your best case and work out whether you're going to need to take the tribunal to any legal principles, and factor in some time for turning up the pages, everybody else turning up the pages, and getting to the point that you want them to get to. So this will give you a rough idea of how long you're likely to take, and then if the tribunal wants to discuss these points with you at the start, you'll have something constructive to say, and if necessary you can explain what you've done in order to try to work out how long it was likely to take you. If you've got any concerns that you're not going to finish in the allocated time, discuss these with your opponent at the earliest stage, and that may be quite difficult, of course, but if there is a lawyer on the other side, just make it clear that what you want to discuss is only the question of the time allocation and how the tribunal's time is going to be insufficient on the current allocation in your view. Or maybe it's something that you want to make sure the other side doesn't abuse. But in any event, discuss the time allocations, how long people are going to be with the particular witnesses, and then if you've still got doubts that you're going to be able to get through the hearing in the time allowed, raise the question with the tribunal when you get into the hearing. Or if you and your opponent have managed to agree on rough time estimates for how long you're going to be with each witness, then let the tribunal know what the two parties are thinking. One development that has come about over the past few years is the availability of electronic means of conducting hearings, and Rule 46 deals with this. Basically, the whole of the hearing, or any part of it, can be conducted by use of electronic communication. The tribunal's got to consider that it would be just and equitable to do this, and it's a necessary condition that parties and members of the public attending the hearing are able to hear what the tribunal hears and sees, and they must be able to see any witness as that witness is seen by the tribunal. Well, this may be quite useful if you're dealing with a sexual harassment case, for example, where you have a witness who, as a result of his or her experiences, doesn't particularly want to be in the same room as the person they alleged harassed them. More commonly, it's going to be used where witnesses are outside the jurisdiction, and that may include the claimant or the respondent. Also, you may think about using it where a witness has childcare difficulties, if it can be conveniently set up. Now, all means of electronic communication are permissible, so video links, Skype, other electronic means are likely to be allowed. But note that electronic hearings are going to take a little more planning. Witnesses have got to have the materials they need to hand, so they will need to have a bundle with them. And they should be able to refer to that in the same way as they would in the hearing room. What that means is that you'll have to have your preparation concluded with the other side in advance of the hearing, and slightly further in advance than you would normally. So there's going to be less scope for additional documents to be introduced which need to be considered. If either party fails to attend or to be represented, then the tribunal can either dismiss the claim or proceed with the hearing in the absence of the relevant party. Rule 47 allows this to happen, but the tribunal is obliged to consider any information which is available to it, and it must also make the inquiries that may be practicable about the reasons for the party's absence. One new aspect of the rules, which may cause some difficulties if it's used very often, is under Rule 48, the power of the tribunal to order that a preliminary hearing can be treated as a full hearing or vice versa. The tribunal has got to be properly constituted for the purpose of doing this, and it must be satisfied that neither party will be materially prejudiced by the change. Well, it won't be proportionate to prepare for any preliminary hearing on the basis that it might turn into a full hearing, so I find it difficult to see that in most cases it'll be possible to use this rule. Parties won't generally be equipped to deal with a full hearing because they won't have the relevant witness evidence together if what they've turned up for is a preliminary hearing. They may well not have taken statements from their witnesses, for example. So it's quite an easy test, I'd suggest, to satisfy this material prejudice test. It'll also be satisfied even if there's a balance of prejudice, because that isn't the test. The test is whether either party is materially or relevantly prejudiced by the change. And of course they may be prejudiced in different ways, but they may well be both materially prejudiced, but it's sufficient that one party is materially prejudiced. So, for example, the issues may well not have been defined by the time of the preliminary hearing. Plainly that will be a material prejudice to both parties. So I don't think it's likely to be used very often. Majority decisions are possible. If there's a two-person panel, the employment judge has a second or casting vote. Don't get your hopes up if you find that you have a majority decision. Some tribunals manage to disagree over matters such as the relative fairness of a dismissal without necessarily reaching a different conclusion in law. But basically the votes of all members of a three-person panel are equal. I want to turn next to the privacy rules under Rule 50. So the tribunal can make an order of its own initiative or by the application of a party with the aim of preventing or restricting the public disclosure of any aspect of the procedures. It has to consider that it's in the interests of justice to do this, or to protect the convention rights of any person. There's also a requirement to consider restricted reporting orders. However, the principle that there should be privacy in any case has to be weighed against the principle of open justice, and also has to be weighed against the convention right to freedom of expression. Having said that, if it decides to make an order, it can make any appropriate order, including that a hearing that would normally be in public can be conducted in private, either wholly or partly. If you think you may have a hearing that needs to be in private in part, then it's sensible to create a distinct part of the witness statement which deals with this evidence, so that there's a clear demarcation line for everyone, so that they know when they're coming to the part that must be heard in private. In practice, the tribunal puts a notice on the door saying that the hearing is in private. Secondly, the tribunal can make an order that the identities of specific parties or witnesses or anyone else referred to in the proceedings shouldn't be disclosed in public, or to the public. Now, it can do this by the use of anonymisation or by other means, and it can do this whether in the course of any hearing, or its listing, or in any of the documents which are entered on the public register. So this is a very extensive power of privacy, but it does need to be exercised having regard to the need for open justice. The need for open justice, remember, may outweigh the desire of both parties to a case. Both parties may want to have certain aspects of the hearing in private, but the tribunal will not necessarily agree to do this. The tribunal can make an order for measures preventing witnesses at a public hearing being identifiable by members of the public. So, for example, witnesses could give evidence from behind a screen, but it seems to me that a witness wouldn't be able to give evidence via electronic means as a way of ensuring privacy, because of the rule on electronic hearings, which requires that members of the public and parties attending the hearing are able to hear what the tribunal hears, and also see any witness as seen by the employment tribunal. So I think it's unlikely that you could simply use electronic means to ensure privacy. A restricted reporting order can also be made. If it is made, it's got to specify the person whose identity is protected, and it may specify particular matters in relation to which publication is prohibited. The order must specify its duration, and the tribunal has to ensure that there's a notice put up that an order has been made and displayed in the way described. Now, anybody who's got a legitimate interest, so parties or anyone else with a legitimate interest, who hasn't had a reasonable opportunity to make representations before one of these orders is made, can apply to the tribunal in writing, asking for it to be revoked or discharged. And that can be done either on the basis of written representations or at a hearing if one's requested. Now, the press occasionally ask for this kind of hearing, and you should recall that costs can be awarded against unreasonable interventions of this nature. If during the course of a hearing a claimant says that their claim or part of it is withdrawn, then it comes to an end. The only thing that remains is the ability of the respondent to apply for costs, preparation time, or wasted cost orders. So Rule 51 allows the claimant to inform the tribunal in writing. That can be done during the course of the hearing, but also orally during the course of the hearing. They can say that their claim is withdrawn. Rule 52 deals with what happens after that. So where there's been that kind of withdrawal, the tribunal has to issue a judgment dismissing the claim or the relevant part of it. And the rules spell out that this means that the claimant can't commence a further claim against the respondent which raises the same or substantially the same complaint. Now, you'll hear lawyers talking about estoppel in these sorts of circumstances, but essentially that's what it means. It means slightly more than that, but there is a species of estoppel which is raised in this way, and it's now spelt out in the rules. However, the way in which a claimant can be prevented from bringing a further claim is slightly modified by these rules, because the tribunal doesn't have to issue a judgment dismissing the claim or part of it with the consequence that the claimant can't start a further claim. If the claimant has expressed at the time of withdrawal a wish to reserve the right to bring such a further claim. In those circumstances, the tribunal has to be satisfied that there would be a legitimate reason for the claimant doing so, or there's a more general power whereby the tribunal doesn't have to issue a judgment dismissing the claim if it believes that to issue such a judgment wouldn't be in the interests of justice.